Okay, so welcome everyone to the second webinar of our thematic series on IHL and humanitarian negotiations. My name is Hala El Khouri and I'm an operations manager at the CCHN, the Center of Competence on Humanitarian Negotiation. So I'm very thrilled to see so many people join us today. And I really want to thank you for taking the time out of your very busy schedule to be with us. Perhaps many of you already know the CCHN in this webinar, so you may be familiar with what I'm about to present shortly. But for those who don't know the center yet, please allow me to take a few minutes before I leave the floor for our speakers today to present and say a few words of introduction about the Center of Competence on Humanitarian Negotiation. So the CCHN, or the Center of Competence on Humanitarian Negotiation, is a joint initiative. It's a strategic partnership between these four organizations: the World Food Programme, UNHCR, ICRC, and Médecins Sans Frontières. The center was founded in 2016 to enhance professional exchanges and peer learning among frontline humanitarian negotiators, and we are currently based in Geneva. So what does the CCHN do? The CCHN provides a wide range of learning and sharing opportunities depending on the needs of either individual practitioners, senior managers, executive managers as well, or the humanitarian agencies as organizations as well. We provide these practitioners with a safe and confidential space to exchange on their practices and develop their negotiation skills, either through experience-based workshops, but also through other spaces of exchange and learning. Most of our activities are available in multiple languages, from English to Arabic to French to Spanish, and are free of charge. So aside from the workshops with the members of our community of practice, we capture and analyze current negotiation practices. We develop together strategic negotiation tools. We also provide tailored support for organizations who wish to strengthen the capacity of their staff members or to overcome certain negotiation challenges that they are facing as well. So at the core of the CCHN is the CCHN community of practice, which today, aside from the number you see here on the screen, counts more than 8,000 humanitarian professionals working at the front lines of humanitarian crises around the world. So you see the representation. We have more than people coming from more than 150 countries, from different types of organizations, and they are really located all over the world. I'm sure many of them are in this webinar today, so please join me in giving them a shout out as well. And this community of practice, one of the main or the common denominator is that we all share a passion and an interest in the subject of humanitarian negotiation. So we have this space through the CCHN to get together to discuss the challenges we face when we are engaging and negotiating, but also exchange and learn from each other on the good practices as well. So a small word about the rationale behind this thematic series. So perhaps some of you were here last week when we launched the first session webinar with Jose Serralvo from the ICRC. This is the second webinar of this thematic series. And just like a few words about that, we actually designed it following discussions we were having as part of the community of practice in our thematic group around protection-related negotiations. And indeed, like one of the common or most common frustrations that humanitarian negotiators shared with us is this disconnect that can arise between normative legal frameworks, which we are supposed to uphold as humanitarian professionals and actors, and which underlie our humanitarian response. And the disconnect between those and the operational realities and difficulties and the dilemmas that we face in the field. Many shared with us that this gap or this disconnect created overwhelming feelings. And I think that these overwhelming feelings have been even more exacerbated over the past couple of years, where we feel like these legal normative frameworks that we are trying to uphold, we feel a sense of futility or a sense of being doomed to failure, particularly when we are negotiating and upholding the protection of civilians in armed conflicts. So together with the members of our community of practice and with the team over here, we reflected on how do we bridge this gap? How can we address these barriers or these overwhelming feelings that professionals are facing? So we concocted this exciting speaker series. This is a series of webinar from now until the end of the year, but also into 2025 as well, to explore the intersection between IHL, other normative frameworks as well, and humanitarian negotiation. We felt that this year was even more relevant to launch it as we are celebrating the 75th anniversary of the Geneva Conventions. So this is the CCHN's contribution to create a safe space for practitioners like us to discuss, to explore, and to expand our knowledge and skills around this topic. So without further ado, welcome to the second webinar, where we will explore the critical intersection between IHL, humanitarian principles, and humanitarian negotiation. Please join me in warmly welcoming our key speakers for this afternoon. So we have Jonathan Sommer as a legal advisor at the Danish Red Cross. Jonathan has over 15 years of experience in negotiating with state and non-state armed actors. Prior to joining the Red Cross and Red Crescent movement, Jonathan has worked with Geneva Call and the Organization for Security and Cooperation in Europe. As a consultant, he advised, among others, the United Nations and the government of Denmark. So as a background, Jonathan holds a JD from the University of British Columbia, LLM from the Geneva Academy of International Humanitarian Law and Human Rights, and has been awarded the Henri Dunant Prize for his scholarship on IHL and armed groups. Our second key speaker for this afternoon is Dr. Rob Grace. Rob is the lead researcher for Watchlist on children and armed conflict. He teaches courses on humanitarian action and international relations at Tufts University and the University of San Diego. Previously, he led research projects on humanitarian negotiation and humanitarian civil-military coordination at the Harvard Humanitarian Initiative and the Center of Human Rights and Humanitarian Studies at Brown University. Rob holds a PhD in political science from Brown University, where he wrote a dissertation analyzing humanitarian access negotiations. So as you can see, we have a rich panel today of speakers. I'm very excited to launch the second webinar with you. Please note that we will have 2 times of interventions. You have in the Zoom option to ask your questions in the Q&A. Over here and behind the scenes, you don't, maybe you see them. I don't see who is sharing their cameras or not, but we also have our CCHN team here with Ms. Barbara Sartore, our head of communication, who will be moderating the questions and answers section with me. So thank you, Barbara, for helping out. And we also have Ms. Ines Lahlil, our associate as well, working for the operations in Europe, but also on protection and healthcare, and who will be tech hosting this webinar as well. So as I mentioned, we will have 2 sections. We will start with Jonathan, who will cover with us some fundamentals about IHL, and then start zooming in on how IHL intersects also with humanitarian negotiation. We would stop a little bit to take a few questions and answers, and then we will give the floor for Dr. Rob Grace, who will continue taking us on this pathway together, and then we can conclude with a last round of questions and answers. So we're expecting to spend together around 2 hours. We hope that you would stay throughout this whole time as well. And yes, please let us know if you have any questions and answers. You will see that you don't have the possibility to speak freely because we are expecting a large number of people, but please feel free to raise any question you have on the question and answer function. And me and the colleagues, we do our best to cover them as well. So without further ado, I have the pleasure now to hand the floor to Jonathan, who will be our first speaker for this session. Thank you again. And Jonathan, the floor is yours.
Okay. Well, thank you very much, Hala. And thank you very much also to your team for inviting me to speak today. One thing I think maybe I'll start off with is both Rob and I are native English speakers, and therefore we'll try to speak slowly to make sure that everyone can be on board with what we have to say. I think it was quite compelling what Hala said about the overwhelming feeling that many people have and many people in our humanitarian industry have these days in terms of the scale of the challenges we face, and you know, to be quite frank, the perceived inability for IHL to do what we want it to do to stop the suffering in armed conflict. So I think what I want to do today is have that, you know, constantly hanging in the background, and I think it's something that we should be able to have a honest conversation about. And a lot of that has to do with what our expectations of IHL, how do we use it, how do we not use it, and also to look to some examples where it may or may not be used. I think I will be a little bit more on the explanatory side of trying to give a sense of, first of all, how does IHL fit into the grander scheme of international law, and how does it interact with other areas of international law, particularly the legality of the use of force. I'm going to want to then look at the rationale, so big picture rationale of IHL, and to dive down a little bit into some of the detail. I'm not going to be redundant with what Jose, my colleague from ICRC, presented last time around. I'm not necessarily going to go deeply into the details, but we certainly have tools where anybody who's interested in diving deeper into the actual rules themselves will be able to do that. I'm a little bit more interested in, again, how we craft, how we use it. And I think Hala said something the other day about some of the sugar and spice around these issues. I'm going to end up with a bit of a deep dive on the issue of negotiating around children and armed conflict before I hand over to Rob. And the first question I guess we want to look into is why are we here having this conversation about IHL? And so here's an academic view that says humanitarian negotiations are generally understood to be framed by IHL and guided by humanitarian principles. So again, we're looking at what does it mean to be framed in this context? What do we need to know? What do armed actors need to know in order to try to maximize the ability for IHL to make a difference? I'm going to ask Ines right now if she will show a short, very short video clip, and hopefully our technology will do us well. Ines, over to you. And if you need me to stop sharing, apparently you don't.
This is an enemy soldier, you know? My daughter is a civilian. You need to take care of her first.
Listen, everybody's getting help, and that includes soldiers. He's in a critical condition.
Okay, thank you, Ines. What you saw there, it looks like I may need to re-share my screen. So what you saw there was an example of a very quick humanitarian negotiation that was based in IHL. In this case, it was a humanitarian worker negotiating with a very bereaved or a very anxious father of a civilian who was injured, while at the same time caring for a soldier. Now, the rules of IHL are quite clear. In such a context, it's the person who is in most dire need of medical assistance who will be prioritized regardless of affiliation. And again, even regardless of whether soldier or civilian status. So there, what you were able to see was an example of a humanitarian worker framing the negotiation in IHL, but obviously appealing to other things around the situation that she found herself in. I'm going to give a quick shout out where that came from. It's a new film on IHL promotion, IHL dissemination that has just been released by about 30 some odd European national societies of the Red Cross and Red Crescent, together with the ICRC. It's called If War Comes to You. And if it's possible for somebody to put ifwarcomestoyou.com in the chat, it gives you the opportunity to see the life, a day in the life of either a civilian, a soldier, or an aid worker. You can choose, and you can choose your own path in this. So please have a look and share it with those around you. With that plug off the table, I will now go, start to move forward. And essentially, I think this is a pathway of what we want to see in an ideal world when we look at what it would be great if armed actors know. So on the picture on the left, you see, that's me in this case, working with leaders of an armed force, or at least higher level commanders, towards, okay, here are the norms of IHL. This isn't particularly a negotiation. The negotiations here happened prior because my colleagues had negotiations with the leadership of this armed force. They decided they wanted to know more about IHL. I came in and we had a seminar around it. So that knowledge gets to the leadership. But I think what's super important here is if we look to the picture on the right, where we see actually commander, and this is, small level, platoon level group, but they're actually looking at and disseminating these norms themselves. And in fact, they're taking ownership of these norms. So in an ideal world, this is what would happen. And when you as a negotiator came in to meet any of these people in your daily work, then this would have been disseminated not necessarily from outsiders, but from their own chain of command, from their own what they're committed to, what they have an obligation to to follow commands and to be committed to. So there we have the way that things would work in an ideal world, vis-a-vis the people, the counterparts that you may face in a negotiation. So to take a step back from there, which I promised to do, I want to frame this conversation in what IHL is not and what it is in the context of international law. The reason I have this big red bar in the middle, it's to represent a firewall between these two areas of law, jus ad bellum, which if you're not great at Latin, like I am not great at Latin, it means when it's lawful to use force. And essentially that's now governed by the UN Charter, where I think many of you know that it's only lawful to use force, either as an act of self-defense or in conformity with a decision of the authorization of the UN Security Council. But whether or not a conflict is lawful or not, that does not affect the use in bello, which is essentially international humanitarian law. Before I get there, I want to talk about a couple of things that we're seeing a lot these days in conflicts that are up here in the jus ad bellum in the top square, so that we, again, get an understanding of how these things relate, or essentially how they don't relate. So I think we've heard a lot about the notion of aggression and accusations of one state being an aggressor vis-a-vis another state. It's probably a good time for me to say, obviously, I'm working with Danish Red Cross, with the Red Cross National Society. I have to be careful in terms of what I say to maintain my neutrality. The one thing I want to say in this group is that I will potentially use specific examples as learning moments, and not necessarily to pass judgment on any party to conflict, but simply to help you to learn what the law may be. So, as I say, we've heard a lot about aggression and whether one country is the aggressor and the other country, that means, is a victim of aggression. So as much as that makes a huge difference and has a huge consequence in terms of international criminal law, because we know that the aggression is a crime. When it comes to IHL, it's not a relevant factor, because what we see in the bottom right is the equality of belligerents. That means that all parties to conflict have the same rights and responsibilities, no matter who is right, who is wrong, who is the aggressor, who is the victim. We'll also bring it back up to the top, because again, we hear a lot about the right to self-determination these days. There's also scholarship, discussion, debate in terms of whether that right entails the right to violent uprising within the notion of the right to self-determination. So whether or not one believes there is such a right towards the use of violence in that context, it does not cross over the firewall in terms of what is the red lines in an IHL context. So again, no matter why one is fighting an armed conflict, whether it's justified or not justified, the rules of IHL to limit the negative effects of armed conflict will always be there and always will be the red lines. The other thing that I wanted to talk about in this context is the notion of non-reciprocity. That might be slightly difficult for even for English speakers, I think. So what it means essentially is that it doesn't matter what the other side is doing, whether they're complying with the law or not. The obligations of each side are based on their own obligations and are not reciprocal. This is actually a pretty new notion in international law, and it really doesn't exist in all areas of international law. It's quite exclusive to IHL, or which is also known as the law of armed conflict. But it's quite essential and it's quite crucial, because if it did depend on what the other side was doing, we would likely face a spiral of violence that would be justified based on the actions of the other side. And this is clearly why in 1949, with the current Geneva Conventions, of which we're celebrating 75 years anniversary, why the drafters of the convention, and I should say every state in the world, agreed to have these obligations as absolute obligations. Now, that's going to cause some serious challenges for anybody trying to negotiate with a party or an individual that feels aggrieved. And let's face it, in most contexts, you're going to be dealing with someone who feels victimized for one way or another, whether you agree with that, whether the world agrees with it. But generally, people are going to be arguing and negotiating from a sense of feeling somewhat victimized, and that's why they're involved in an armed struggle one way or another. So one of the things that I think is really important that's come through in my experience is the need to allow for some time for venting. The party is likely going to talk about, well, you're coming to me, why are you coming to me about this? Because look at what the other side is doing, and you shouldn't be wasting your time on me, you should be going to them. So that's a legitimate, whether or not it's a legitimate claim in any particular context, it's a legitimate feeling for that person to have. And what I think is really important to do in that context is to be able to allow that person to vent, to share those perspectives. And, hopefully you'll be able to say, well, I understand that this may be happening, and this is how that's being dealt with. There are other people speaking to them, or I'm going to be speaking to them on Tuesday, or this organization is speaking to them, but to somehow be able to give an understanding of that voice, and then to, when the time comes, to shift it back to, okay, now we have to focus on what you and I can do in this room, because we can't, between you and me, affect what's going on the other side. So that's a function of the notion of non-reciprocity, of the grievance of saying, why are you coming to me with this stuff when the other side isn't following? So I think we're going to move on, and hopefully that's clear in terms of what IHL is not, and we can get a little bit more into what IHL is and how there's a firewall between the justification for the use of force, good guys and bad guys, and the red lines, the minimum standards that IHL represents. So I'm actually going to ask you a question here. On this slide where I'm talking about what IHL seeks to do, I've put two things, two images. I'd like to ask you why you think I've put a Band-Aid and why you think I've put an elastic band. Feel free to choose one, the other, or both. And I'd certainly be interested in hearing from you why you think I've done this. Again, if we have the technology.
Yeah, we do, Jonathan. Thank you so much for launching this first. So if anybody would like to react on this first question, you can simply raise your hand using the raise hand function, and my colleague Ines will give you the green light to unmute and to speak. And I already see that we have two people with their hands raised. So you have John. We have 5 already. Maybe let's take a first intervention from John.
Okay. Thank you. For me, I think the reason why you have one with the what do you call it, with the contested band, you know, with two sides pulling, is because they're for me it's like there are contested components of the IHL. Some people are not agreeing about it, but the red band also says that yes, we agree, we are willing to abide by it, but you know, there are certain areas we won't go to, but the one with the rubber band having two sets of folks pulling at it is like saying, look, I know, right, we agree to the IHL, but we don't agree. You know, we agree, but we don't agree.
Perfect.
Well, thank you, John. Hello, can we just collect maybe, I don't know, one or two others? And,
Of course.
and then we can continue, but thank you very much, John.
Thanks, John, for this first intervention. We also have Oriane Simonin next in line. Oriane, the floor is yours.
Thank you. Why I'm not sure, I would tend to say that the Band-Aid code represents, so basically I see war as something that will harm societies and the people in that society, and while international humanitarian law cannot stop it from happening, it can, however, serve as an instrument to patch up the wounds that war causes on society and the civilians, the same way that the Band-Aid can patch up.
Okay, well, thank you so much, Oriane. Jonathan?
Yeah, do we want to go for one more, Hala?
Sure.
And then I think I don't think we should eat up too much more time on it, but let's maybe go for one more if you can choose.
For one more, we have Olga Veprek. Olga, the floor is yours.
Good afternoon, everyone. It's Olga Veprek here. Jonathan, I think your keywords are the two words protects and restricts. So the rubber band could be suggesting that the international humanitarian laws could be stretched somewhat. The Band-Aid could show that the law temporarily restricts and covers inconsistencies of a particularly dangerous situation that could be later addressed. So it's a temporary Band-Aid.
Well, thank you, Olga, and thanks, everyone. And I think really you hit the reasons, and actually John added an extra reason that I'll come to as well that I thought was quite interesting as to why I put these on the slide. I mean, the Band-Aid is there to clearly represent the notion that IHL is not the answer. Conflicts need to be solved in ways that they can be solved, and IHL can only limit the effects. Even if IHL is fully complied with, I think it's fair to say in almost every single conflict that would ever exist, there would still be a vast amount of human suffering, degradation, civilian loss, civilian damage to civilian objects. So I think what's also really important for us, and also people who are seeking to promote the value of IHL, is that we shouldn't raise expectations too high. If we come out and say, well, we just need the parties to comply with IHL and all will be fine, well, certainly that's not going to be the case. And we'd be selling ourselves too high. So it is important to have realistic expectations about what is capable here, and that it's a temporary relief, but just like a Band-Aid isn't going to be able to stop the problem, to stop all the bleeding. It will, and it does actually make a difference on a day-to-day level. In terms of the Band-Aid, in terms of the elastic band, John, I think that what you talked about, the contested nature of it, I didn't even have that in mind, but it makes a lot of sense because it is somewhat a debate that that parties will go into and saying, well, I'm complying, no, you're not complying, et cetera. And we find this, and some of you might have heard of the notion of lawfare and what it means to be using IHL towards, actually towards your objectives of being involved in a conflict. What I was getting at here was what I think one of the others mentioned, maybe Oriane, was the notion that this law is very pliable. There's a lot of room, there's a lot of ambiguity, and there's a lot of bendability in terms of what parties can do. And, for example, the notion of proportionality. Well, I can launch an attack that might have severe or serious consequences for civilians, as long as those consequences won't be excessive to the military advantage expected. So there is a lot of pliability in that. There is a lot of room for actions under military necessity. And it's not necessarily comfortable because we want answers, we want clear limits. But what we again have to realize is that this is a set of rules and law that were created when every other set of rules and conflict resolution has broken down. So again, that's why we can't have too high expectations, and that's why we have to understand that this is a very pragmatic law, and it's a law that can only aspire to achieve so much. And that pliability is built into that. So thank you very much for your interventions, and I'm going to move on. And I think, the key message here is this is exactly what IHL is it's an uncomfortable balance between humanity on one side and military necessity on the other side. If the scales go too low on the sense of humanity, meaning humanity weighs too high, then parties to conflict are going to simply ignore it. If it goes too far in the notion of military necessity, which I think many people may be feeling is the case in many conflicts today, then humanity is going to suffer, and we need to work to get that balance back, at least to a balance as uncomfortable as that may be. So I actually wanted to show you something very quickly about what are basic rules of international humanitarian law, because I did tell you that I wasn't going to kind of go step by step. I want to leave you with this, and we'll make sure that either you have access to the slides or you at least have access to this particular sheet, which we've called it sometimes a cheat sheet on IHL, to have a bunch of different rules in one piece of paper or one screenshot. But even here, what I want to say is that it's not always that easy, because, for example, look in the third column, number 2, taking hostages is prohibited. This is a great example of an absolute law of IHL. Under no circumstances are the taking of hostages permitted. There's no way to justify it because, as we saw in the last slide, that balance of military necessity and humanity is has already been made. So another example of an absolute law is the prohibition on torture. Under no circumstances is torture or ill treatment permitted. Again, no matter the circumstances. It's not where a party can say, yeah, but this was a super important battle, or we were really concerned that we needed information, critical information. These are absolute prohibitions. However, there are many other areas of law that are not as clear. And I'm actually, I have my screen a bit covered with some stuff. Oh, here it is. In the second column, 3, forced displacement of civilians is prohibited. Now, if we had more room, we would say except for situations of their own concern for their own safety, or for situations of military necessity, where actually we see doubling down on military necessity, because as I said, it's already built into the law, but some rules specifically refer to military necessity again. So in that case, one is able to bring up as a party to conflict to say, well, you know, for this temporary amount of time, we have to get from point A to point B, so we're going to displace these civilians, although we understand we have the responsibility to care for them and to make sure they get home as soon as possible. So in this way, it's complicated, and the first thing one needs to know is, are we talking about an absolute rule, or are we talking about a rule where there is this elasticity that I talked about? The other problem, of course, is that there's going to be some disconnect between, well, the commander saying, well, yes, we needed to displace these civilians for this reason, and others saying, well, no, they're actually just displacing these civilians because they want to populate this territory with a different ethnic group or religious group or something like that. So again, at the base of any international law is good faith, but we know that that's often hard to achieve, that parties are always coming into a discussion with good faith. The other challenge that we're going to face is what we see again a lot these days is the notion of, okay, using human shields is prohibited, but what does that mean in terms of the other party's ability to attack the context and the situation? So if one party just says, well, we're using, you know, the other side is using human shields, that's why we're attacking this school or this waterworks or whatever it may be, and the other side is saying, look, this other side is destroying our schools. So it's always going to be very difficult and challenging to get to the bottom of that, at least real time. So we do have to take these into our considerations and understand that it's not necessarily the law that's failing here, it's the ability to derive the facts on which the legal arguments are based. So again, we have to assess how far we can go with that and how far we have to then go to other arguments and other ways to try to get the outcome that we want to get. So as I said, I'll be happy to leave you with this table. I'm going to move on from it now. So here's a big challenge that we face when it comes to international law, and that's the trouble of enforcement. On the left picture, you see an example of real-time enforcement. You have 2 football teams. One obviously has committed an infraction, a foul against the other team. The referee is there real-time, holds up the card, and there's consequences. So there's immediate consequences for that action. And that really obviously polices the level of play. Now, there'll still be infractions. There'll still be fouls made, but certainly it will have an impact on limiting the number. Now, on the other side, the reality that we have in international law, and particularly humanitarian law, is we have Team Blue and we have Team Red, and they have to self-regulate their game. There's nobody there telling them what the rules are or how to play. They have to know the rules, and they have to play by the rules in order to get at least a fair outcome in this context. Now, you know, again, this is an analogy. I don't want to belittle war by comparing it to a game, but I hope that the analogy, at least here, comes through in the challenges that we face of not having an international police force. Now, that said, I've been using this slide for many years. I was telling Hala and the others that it started off as an ice hockey slide because I am a Canadian and that resonated in a Canadian context, but I think football might resonate more in a global context. But it's only this year that I've started using the slide showing the International Court of Justice. And the reason I've done that is because it is a recent phenomenon where the courts and also the International Criminal Court are starting to have a real-time impact. It's too early to really understand and know how effective this is, but we do know that in certain contexts that provisional measures have been ordered, that this international court has ordered parties to conflict to do certain things, that parties have at least said, okay, we are taking steps to comply with these orders. And that's, to some extent, it's an encouraging development. But of course, we also have to understand that this can only go so far. In terms of criminal convictions, we've seen even leaders of states with indictments against them. These criminal trials, if they ever come to pass, will take a very, very long time. So I don't want to oversell the relevance of these international courts. But at the same time, I do want to say, clearly one time I was involved in a negotiation, and we'll get to the rules on children later, but a commander clearly came up to me and said, at what age do I need to not recruit children in order to stay out of The Hague? So we don't know the exact impact that these international provisions, and particularly the criminal provisions, can have, but we have certainly anecdotal evidence to show that it's in the minds of military actors. The first thing we need to really understand is, does IHL apply at all? Because we don't want to start applying IHL to situations where it doesn't apply. And one of the reasons is because it essentially is a license to kill. So if we look at the bottom of the table, the lowest part of the table, this is, for example, it could be a riot, it could be an internal disturbance that can happen in any country that's not in conflict. We don't want to apply IHL at such a low threshold because, again, we don't want the police or the armed forces just to be able to come and start firing on demonstrators. In that case, human rights law would apply, and force can only be used as a last resort. But when violence elevates, and here's where it's a bit tricky, because if we look at the top of the table in terms of what an international armed conflict is, it applies almost as soon as force is used across a border. So in a way, it's much easier to say when an international armed conflict has taken place and IHL applies, that's a conflict between two or more states because force has been applied across a border. And then we can say, okay, these rules of IHL apply. It's trickier in what's called a non-international armed conflict, and that means a conflict between a state and one or more armed groups, or it could even be conflicts between two or more armed groups themselves. Here, we have to say that there's some type of level of violence that meets a certain threshold, as well as a level of organization within the armed groups that they're able to have a command and control such that they could apply with IHL, not necessarily that they do. So actually, I wanted to say this. I've stolen, I'll get back to that slide. I've brazenly stolen this slide from my ICRC colleague because I think it's quite hilarious from a lawyer's point of view, because we can sit here as much talking about we classify this conflict like this or IHL applies, etc. But on the right, we have the reality of what humanitarian workers will feel in this context. So with that in mind, and thank you, Jose, for letting me steal your slide. I'm back to this slide here because, in fact, it can make a difference. Luckily, the rules have merged and aligned, so it's not as relevant anymore when we're in a what we would call an IAC or a NIAC, an international or non-international armed conflict. But one big difference is, for example, prisoner of war status. There is no prisoner of war status in a non-international armed conflict. That's essentially because states did not want to say that we're going to give such status of protection to what we consider to be rebels or terrorists or people trying to destroy the foundations of our country. So then if you don't know this and you start going into a negotiation about saying, hey, you have to give ICRC access, which they still may be granted access, but it's not a conventional requirement, or you need to treat this person, you need to give them a cigarette because the Third Geneva Convention says he needs to have a cigarette now. I'm not sure how that will dovetail with the right to life these days. But anyway, we don't want to start applying standards that actually don't apply by law. So that's one of the reasons why I'd say it is important for people to have some knowledge who are negotiating. Again, you don't have to be an expert, but to have some basic knowledge of these laws and rules. Now kind of going on from that, I think we've probably all heard this not very gender balanced statement about one man's freedom fighter is another man's terrorist. I guess you all probably have some certain connotations if you look at the picture on the left compared to the picture on the right. I think we might, one or both of these groups might be deemed as terrorist organizations by certain countries or entities throughout the world. It's important to understand that according to IHL, the notion of terrorism or terrorist organization is not relevant. There's a provision of IHL that it's prohibited to terrorize civilian populations primarily motivated by using terror. But we don't use the discourse of terrorism in IHL. There's parties to conflict. And what we want to judge and work with is, does this party comply with IHL or does it not comply with IHL? Even though by others, these parties will likely be called terrorists or for example, freedom fighters or whatever, liberation movements, whatever the terminology may be used. It's a little bit easier when we have our IHL lenses on because, again, we're talking about parties to conflict, and it's based on their behavior, the way that we work and try to engage with them, not on how they are labeled. Then I promised that I would move on to a little bit about children in armed conflict. So if we focus on the left here, we have a general requirement of IHL that parties to conflict must provide children with the aid and care they require. That means their physical safety, basic needs, education, family reunification. And here we also see the notion of recruitment and use in hostilities, the ban on the recruitment and use in hostilities. Now, there's a lot of focus on child soldiers, and I'm only including this very complex table on the right because I was once asked to train investigators in this area, investigators in international criminal law, and I wanted to show them how complicated this could be in terms of what's the age of recruitment limit, depending on, are we talking about international criminal law, IHL, what type of party it is. This is a bit, I'm not going to go into the details, but it's a blending of IHL and international human rights law that creates these complicated standards. We might be tempted, and I know that often many actors have gone out and just said, hey, listen, guys, let's forget about all that. 18 is the age, it's the standard, don't recruit below that. Now, I understand the appeal in doing that, but what happens then is these actors come back, and I've seen it. Hey, I just saw in the BBC that, in this case, British had under 18 soldiers in Afghanistan. Maybe not necessarily that they were used in the fight, but they saw a BBC report on that because, again, we live in an age where people understand, they see the media, they're very internet savvy. Or, hey, I looked at the Geneva Conventions and it says the age is 15. What are you trying to pull on me? And that can have an impact on the trust and credibility of the relationships that you as an engager, at least if you have the ability to engage in a longer time, have with your interlocutors. So again, here we're in an unfortunate situation where a vast, majority of people would love to see the age of 18. And it doesn't mean that we can't advocate for that age, but it does mean that we have to come in with some eyes wide open and transparency around what these standards are. And in fact, we can turn it around. And I've done it before to say, listen, we understand that there's not universality here, but if you agree to these standards, you're contributing to that universality to help protect children. And I think maybe that's what I'm going to end on saying about the notion, because where I feel that maybe I've gained the most interest by interlocutors that I've been talking to is if they're describing a situation and I've been able to say, hey, that's really interesting. We, on the outside, who aren't in your situation didn't know that. I'm going to take that back to Geneva and let people know in Geneva that this is something on the ground that you're facing, because that's going to help us to better understand how to implement IHL, how fit for purpose the rules are. And when they feel that we're, as an international community, actually engaging them in that way, suddenly their ears perk up and they start to engage more actively, I would say. So I look forward to a discussion. I look forward to engaging with Rob as well and all of you, and I'm going to hand it back to Hala there.
Great. Thank you so much, Jonathan, for this really interesting presentation. We already have a few questions in the chat box, but I'll also invite if anybody would like to ask their question live, don't hesitate also to raise your hand, and we can take a few questions also from the public as well. So I think it's relatively easy because I have 3 questions in the Q&A. We'll start with the first one with Flavio, who is asking, so what leverage? So we spoke a lot about like IHL and how it applies in international, non-international armed conflict. However, what is the leverage that we as humanitarian negotiators, we can use in other situations of violence, such as also like internal disturbances as well, which are neither classified as an international armed conflict or non-international armed conflict, to ensure the protection of injured members of armed groups during their transport and care at the hospital. And Flavio is also asking if you have any examples or success stories to also share with us on this. So let's start with this question.
Well, I have a fictional example that you just saw in the preview of our presentation. I think, it's an interesting question in terms of other situations of violence. We don't have the clear standards of IHL that are applying. I think what the leverage, and I'm really glad that you bring up the term leverage, because, you give a presentation and you always forget to mention the one term that you told yourself you need to hammer people over the head with. And in this case, it's really incentivization. What are the incentives for anyone on the other side of you to comply with what you're asking them to comply with? It's going to be different for different constituencies. There's going to be internal constituencies. There's going to be external constituencies. And again, when we've got IHL, it's a little bit easier because we've got parties to conflict. We've got those who have the obligations under IHL. In other situations of violence, it might be a little bit fluffier. Although I do think we can appeal by analogy to say, look, you're in this situation, violence is being used. These are standards that are often implied in this. These are norms that are applied in this type of situation. Can we try and work towards, agreeing with these standards? Again, maybe if somebody's being detained, let ICRC come in and visit if they're available to do that, even though it's not a legal obligation. In terms of ambulances, et cetera, or in terms of letting people through checkpoints, I think that's probably quite a strong situation where that might arise. Here are the norms that we'd like to see, because also it's not always easy to say there's a conflict or there's not a conflict at this particular time. So maybe a bit more of a normative approach and having these norms come in. But in terms of the leverage, again, we have to understand what incentivizes the person across from us, internal and external, and try to work with those.
Thank you so much, Jonathan. I will perhaps take a question live. We have Abdel Halim with the hand raised. So Abdel Halim, we will just make sure that you can speak, and please, the floor is yours. It's really nice to have you with us today.
Thank you, Hala. Thank you, Jonathan. My question is, honestly, law is not my area of expertise, but do you agree with me that to advocate for the IHL, we need to explore different areas? Nowadays, we have been seeing a trend of lack of IHL respect. And from my understanding that we keep advocate for respecting the IHL. Do you think we need to explore different areas that maybe the root, that let's say why the IHL is not respected? In general, I can say that the international law is not respected in general. Some terminology was added, like the terrorism. You just mentioned the terrorism. What is terrorism? How states are dealing with terrorism? Collateral damage, human shields, private security groups, affiliated groups, militia, those whole like armed non-state groups. And also the areas of the ban of weapons of mass destruction, the respect of international treaties and agreements, the International Criminal Court, also I mean, not the respect, but let's say the accountability of those international security bodies and international legal bodies. Do you agree that this area should be explored to advocate for the IHL, or let's say the roots of respecting IHL?
Good. I really appreciate the question. I'm going to have to contain my answer because we could certainly spend the next hour talking about nothing other than that. And again, I'm going to bring it down to the fact that, you know, if we lived in an ideal world, I would be all for changing lots of things and saying, okay, we could improve this, we could improve that. Again, I'm going to bring it back down to that uncomfortable balance that I showed before. And I think our goal should be to have those scales as close to possible as we can, even in an uncomfortable balance. Because I do think part of the reason and again, it's not to discredit the lives lost, the suffering, but I think part of the reason that we are dissatisfied is that sometimes our expectations are high. That's not to let any parties to conflict off the hook, because I also understand clearly that there's a unacceptable amount of non-compliance with IHL. But I think if we could be successful of pushing it back towards, again, that the Band-Aid, the elastic, I think has gotten stretched too far. Too much permissibility. So let's try and bring what we have back a little bit more in good faith with parties to conflict and push towards that before we start trying to blow up, I think, the conventions, the legal standards, because again, in the world in which we live, I think we end up in much worse shape than we are now in terms of the standards that we have. And you know, my last point on that is, again, we came here to say the law isn't the answer to everything. And in fact, I need to share my screen again because I think I actually did neglect my last slide, which is, sorry about that. So this is what I would want to suggest about how we should use IHL. Sometimes on the left, we're going to want to slap it on the table. It's going to be forefront and front and center, and we're going to want to know and understand what it is, and again, slap it right down on the table. But that's probably not going to be the majority of times. I think the majority of times we're going to want to have the Geneva Conventions in our back pocket to understand and know what they say, but not to necessarily slap them on the table, and to think, well, how can we use the standards to frame, going back to my initial slide, to frame the conversation, but to use a language and dialogue that the person on the other side of the table will, that will resonate with them without selling those conventions short. So I think I'm going to end it with that. And again, thank you very much for the questions, and I pass it back to Hala.
Thank you so much, Jonathan. There are so many other interesting questions. Just to also reassure, we also have 4 hands raised. I'm not sure, Jonathan, if you want to take one last one, and then we can hand the floor to Rob. And
why don't we put these on hold so that Rob also has an opportunity to address the rest of the questions that come out.
Sure, sure. So for those who have their hand raised, we see you. You can drop them now. You can raise them later. You can keep them raised as well. And for those who have written their questions in the chat, also don't worry. I don't promise that we will address all of them because for the sake of time, but also I'll try as well to diversify a little bit either in terms of theme or angle, but also in terms of, I know that IHL is a fascinating subject, but I would also like to use the session to explore how we can use it from a negotiations point of view, from an engagement point of view, and to benefit from the expertise of John and Rob around those points. Not that the other angles are not interesting, they're really fascinating. But yes, we will also try to take heed of that as well. But thanks again for all the questions asked. We are putting them in the pipeline, and then at the end of the session, we will continue exploring those. Thank you so much, Jonathan, for this first part of the intervention. And now I have the pleasure to welcome Dr. Rob Grace, who will take us on the second part of the session. So Rob, the floor is yours. And I confirm we can see your screen very well.
Excellent. Thanks so much for the intro. Thanks so much to Jonathan for the initial presentation. And thanks for all the questions. Keep them coming. And I'm looking forward to more Q&A after my presentation. What I want to do in my time here is to build on, hopefully, what Jonathan just said by zeroing in on the role that discourse of IHL and humanitarian principles can play in a negotiation. So what are the dynamics of actually introducing language of IHL and humanitarian principles into your humanitarian negotiation when you're engaging with a counterpart who's a party to armed conflict? But before I get into that, I want to talk about an elephant. And the reason I want to talk about an elephant is because whenever I talk about humanitarian negotiation, I am reminded of this old parable that comes from hundreds of years ago. It first popped up in some early Buddhist writings, but it's a parable of a group of blind men. And again, I apologize for the lack of gender inclusivities, but in the parable, that's what it is. It's a group of blind men who have never encountered an elephant before. And they encounter an elephant, and each one of the men in this group approaches a different part of the elephant. There's one man who's in the front, one who's in the back, one who's at the side, and they're trying to figure out what this is that they have approached. And the one who's at the front with the trunk is like, I think this is a very large snake. The one who's on the side is like, I think it's some type of wall. There's one man who's near the ear, and he says, I think this is some type of fan. And there's one in the back that says, near the tail, that says, I think it's a small snake. So they're all seeing a different part of this same thing, and they're all perceiving it in a different way. In some iterations of this parable, the blind men then get into an argument because they cannot agree on what this thing is that they're touching, and they think that the others are completely perceiving it incorrectly. But I bring this up because this is what I see we are doing in this room today. This is what I see that CCHN does, is essentially we all have come to this topic of humanitarian negotiation, and we all, in our experience or with me in my research, we have all touched some portion of the humanitarian negotiation elephant. And it's only by bringing us all together to talk about it where we can hopefully get our best sense of what that humanitarian negotiation elephant actually is. What is this actual thing that we're engaging in? And I come here as a researcher, so not a practitioner. So I come here very humbly as someone who essentially tries to gather data about what practitioners are doing in touching different parts of the elephant and try to bring it all together and draw some insights about it. So conceptually, that's what I see what we're all doing today. We're all engaging in that type of process. So here are a couple entry points to how we might think about bringing IHL and humanitarian principles into humanitarian negotiation from the standpoint of negotiation theory. So I'll start with getting to yes, since I used to be a fellow at the negotiation program at Harvard where this whole getting to yes thing came into being. I'll start with this. And by the way, I'll say, so this book first came out in the 80s, but actually decades earlier, a woman named Mary Parker Follett had already introduced a lot of the ideas that this framework builds on. So I got to give her credit. And they said they did not necessarily give her the credit that she deserved. So I'll give her the credit today. But essentially, this framework, this idea, this approach to negotiation, it's called integrative negotiation. And some of the key principles are focus on interests, not positions, separate people from the problems, generate options, and use objective criteria. And essentially, the overarching approach is let's sit down with our counterpart, let's build a relationship of trust, and let's creatively brainstorm how we can find some type of solution that satisfies both of our interests. One example that they give in the book that I think conceptually illustrates it very well is an example of two people arguing over an orange. Two people both want this orange, and they're having an argument about who's going to get it. And only through discussing why they want the orange do they realize that one person wants the orange because they want the peel, because they're making some kind of salad dressing. They want a little citrus. They want to scrape the peel into there. The other wants the pulp because they're making juice. So actually, initially, their positions were contradictory, but the underlying interests were actually not contradictory. And it's only through talking about it that they could reach that conclusion. So essentially, that's the gist of what they call integrative negotiation. But the idea of integrative negotiation is let's not do a thing where one counterpart stakes a position and says, I want this. And then the other side says, no, I want this. And then they get into an argument about it. They make threats. And basically what happens is probably the most powerful counterpart will prevail. Let's not do that. Let's do this other way that is much more collaborative. One reason that this could be a useful way to think about it for humanitarian negotiators, picking up on the comments that were in the Q&A about leverage, is that in many contexts, you do not have much leverage as a humanitarian negotiator. There's not much that you can threaten. And really, you do not want the process of humanitarian negotiation to be something where you are making threats. There are ways in which that does come into humanitarian negotiation. You can threaten to publicly denunciate or scale down operations or withdraw, and that does come up, but it tends to be more of a last resort type of option. But this is the integrative approach. But I want to highlight this thing: use objective criteria. So in the integrative approach to negotiation, the idea is let's not argue about it. Let's go to some objective criteria that we both think is completely credible, and we'll use that as a framework for resolving our differences. And I introduced that because in many of the early interviews I did with humanitarian negotiators when I first started doing research in this area and interviewing them about, how IHL plays into their discourse of humanitarian negotiations, essentially I heard something repeatedly, which is humanitarian negotiators introducing IHL into the discourse, thinking it will be considered objective criteria because you're negotiating with a party to armed conflict. If it's a government, they've already agreed to this, but actually it does not serve this purpose. And it actually increases tensions, and it's you, the humanitarian, putting forth a norm that actually your counterpart actually winds up pushing against, and it's not a productive route. So it's a complication for this integrative approach, introducing IHL into a humanitarian negotiation. So that's one sort of vantage point from negotiation theory that we can look at this topic, I'll throw out another one that comes from CCHN itself. So people who are out there in the Zoom room today who are members of the CCHN community of practice and have taken the workshop know this framework. Some of you may have not taken it, might not know the framework, so I'll just sort of lay out some of the basics of it. But there is this idea that is in the CCHN field manual of engaging with your counterpart and considering what facts do I and my counterpart both agree on, and what norms do we share? What are the agreed upon facts? What are the contested facts? What are the convergent norms? What are the divergent norms? And this is what the overarching tool looks like. The idea is to build an island of agreement that starts with agreed upon facts and convergent norms, and then to build out from there. So what I want to do here, what I'll be talking about mostly, is zeroing in on this notion of convergent norms. We don't want to assume that our counterpart shares our norms. We want to identify, through like analyzing our counterpart, what are really the actual norms that are convergent and what are the ones that are divergent. And that's going to inform how we're going to approach the humanitarian negotiation. So I'm going to break apart that notion of convergent and divergent norms and what that means a little bit. I'm going to lay out a framework that comes from this article that I published several years ago in the Journal of International Humanitarian Legal Studies. It's also available on SSRN, the Social Science Research Network, because this academic article is behind a paywall, annoyingly, but it is available, so anyone who wants to read it can access it. But essentially, I'm just focusing on two things. So I'll lay them out. One is the relationship between a counterpart's interests and humanitarian laws and principles. In our best assessment, does the counterpart have interests that align with IHL and humanitarian principles? Or does the counterpart's interests conflict with IHL and humanitarian principles? So that's one factor. The second factor is the counterpart's familiarity with humanitarian laws and principles. Maybe they have a high familiarity. Maybe they know IHL inside and out. Maybe they've taken Jonathan's training course, and so they've now mastered it. Or maybe they're medium. Maybe they took the course, but they were very tired and they didn't pay attention very well. So they get some aspects of it, but they are confused on some aspects. Or maybe they haven't taken Jonathan's course and they have a low familiarity. Maybe they know very little about this framework. So I'm just breaking up this idea of what is a convergent norm or a divergent norm into these two parts. It might converge because the interests converge with the norm. It might converge because the counterpart understands the norms very well, or there might be other dynamics going on as well. So I'll just say a few words about this aspect of it, familiarity with humanitarian laws and principles. Because as you approach different counterparts are going to have different levels of familiarity. One way to think about it is, I'm just going to use a framework from this other handbook that the HD Center produced many years ago. They break up levels of humanitarian negotiation, which I think is a useful way to think about it, and something that humanitarian negotiators can think about different ways to engage with different counterparts. The high-level strategic negotiation is with senior staff negotiating at the highest political level. The mid-level operational level is negotiating with regional or district level authorities. The ground level, frontline level is negotiating with junior state representatives or armed groups or community members. And basically the insight here is that probably it will be the case that you're more likely to see counterparts with a high familiarity at the senior level perhaps medium at the mid-level, and perhaps low at the ground level. This will not be like, this isn't a cookie cutter thing, but it tends to be the case. When I am doing research interviews with people who have done a lot of frontline humanitarian negotiations, they might not be using IHL very much in their negotiation because that's just not something that's going to resonate with their counterpart. But the more broad takeaway is, let's just think about the extent to which our counterpart might know of IHL and know the content of IHL. So I'll zoom over here to the relationship between counterparts' interests and humanitarian laws and principles. And I'll just say here that this is an area for which there is a rich body of social scientific research that has looked at the question of why is it that combatants to armed conflict behave the way they do? Why do some victimize civilians more than others? Why do some comply with IHL more than others? So I'll just lay out some of these. Compliant Rebels is a book that focuses on non-state armed groups and puts out the argument that some non-state armed groups have a need to demonstrate their legitimacy. They want to project an aura of legitimacy to people in the local community or international supporters who care about IHL and human rights. And those armed groups who have that need for legitimacy will be more likely to comply with IHL. This book, Targeting Civilians at War, is a more pessimistic view on the situation. He looks at the argument that basically, as the costs of a conflict rise, as a conflict becomes more protracted, as it becomes more expensive, as the military toll becomes higher, that combatants are more likely to bring the conflict to civilians as a way to try to hasten its conclusion. Order Within Anarchy. One aspect of this book is actually reciprocity. Again, building on one of Jonathan's comments, as we know from what Jonathan said, IHL says that if one side is not adhering to IHL, the other side is still legally obligated to adhere to IHL. But in this book, one aspect of IHL that he looks at is whether that's true in practice. And basically finds that there are a lot of examples of if one side stops adhering to IHL, the other side will stop as well. It's not always the case, but it is something that empirically he finds. And this is a book focusing specifically on rape during civil war. And the argument that she puts out is that if you have a low capacity, say, armed group or a low capacity government, there can be an incentive for atrocities to occur because it can be a mechanism of building cohesion among people within that group. If they are collectively participating in some sort of atrocity, that builds some type of connection between them, and it's sort of a mode of building cohesion among members of a conflict party. So those are just some things that I just sort of throw out there just so that you all know that there are social scientists looking at some of these issues. One thing that I will flag about all of these pieces and many of the other works in this area is that humanitarian negotiators and the process of humanitarian negotiation just does not appear hardly at all, if at all, in any of these works. These works are looking at the attributes of parties to armed conflict, the nature of the conflicts. They are not looking at the causal power of humanitarian negotiation, at the change that you as a humanitarian negotiator can make, or what the limits of that change might be. So it's something that I'm doing work on too. I'm trying to bring these together because what I see is social scientists at one end of the humanitarian negotiation elephant and the practice of humanitarian negotiation and a lot of the previous research that I have done at the other side of the humanitarian negotiation elephant, and I see it as an area where there's something we can bring together there. But okay, those are just some thoughts on possible connections between a counterpart's interests and IHL and humanitarian principles. So there are no simple answers, of course. There are many attributes that we could consider, but those are some. So what I'll do now is just bring these two factors together and see what happens when these two factors interact. So I'm going to create a 2x2 table that places these two factors into conversation with one another. So first we'll look at, here's a situation in which you have a counterpart who knows IHL very well and has an interest in humanitarian laws and principles. Here is where there can be an opportunity for fruitful normative discourse, where if you introduce the language of IHL and humanitarian principles into your negotiation, you will get a counterpart who is receptive to that. It can be a useful tool in your humanitarian negotiation toolbox in a situation like this. I'll give an example from children in armed conflict, because that is what I'm doing research on in my role at Watchlist. And I'll give an example of recruitment and use of children in the Democratic Republic of the Congo. And I will show some data that comes from something that Watchlist has produced. Watchlist has produced and published a dashboard on children in armed conflict. And what Watchlist has done is taken data that has appeared in every annual UN Secretary General report on children in armed conflict, dating back to 2002, and put all this data into an interactive dashboard. So you too can go explore this data, go to the Watchlist website at watchlist.org and explore trends in data about grave violations against children. So here's what you get if you look at the DRC between 2009 and 2023. So there are a bunch of different lines. Each line is a different type of grave violation against children. The black line that in 2009 is very high, and then it drops in a very steep way and stays pretty low, and then goes down to 0 and stays at 0. That black line is recruitment and use of children. So it was very high, and it was very high, and it was a big problem in the DRC. But at that moment, post 2003 and beyond, the country was in a transition process post-conflict. There was a lot of international engagement. And it was this moment where the government seemed to have an interest in making progress in this area, but it did take a lot of sustained negotiation from many different stakeholders to get the DRC to a place where they actually did in practice end the systematic practice of recruitment and use of children. So this graph shows that. It shows a success in the area of children in armed conflict, a success in efforts through humanitarian negotiation to reduce the suffering during our armed conflict. But you see that there's still much to be dismayed about in this context. The green line is rape and other forms of sexual violence, which still persists at high levels today. The gray line is killing and maiming of children, and you see that is still going on, as well as spikes in 2017. So still, in an overarching way, this context does not necessarily invite optimism. But if we look, we can find some case studies of success that we can examine and try to understand why it is that they were successful and see how we can carry those lessons forward. Let's take a look at what we have over here. If we have a counterpart with high familiarity with humanitarian laws and principles, but not an interest in abiding by IHL, you might find yourself in a normative stalemate. If you are introducing the discourse of IHL into a negotiation with a counterpart who knows IHL very well, but doesn't actually share your norms about protecting civilians, adhering to IHL, it can get very complicated because they can throw a lot of IHL back at you that you might not know how exactly to parlay. And this can be particularly complicated because of that elasticity that Jonathan mentioned and that many of you were talking about in your answers. It's important to understand those points of elasticity so you know what you're getting yourself into if you are in a situation like this. One example that I can also give from the area of children in armed conflict where I see something like this occurring is in debates between UN member states that occur in the UN Security Council in the context of debates about the children in armed conflict agenda. Every year, the Secretary General publishes a report that includes an annex that lists parties to armed conflict that are responsible for grave violations against children. And then there's a debate about it. People do not like to be on that list. It's called the list of shame. But in these debates, you see in many cases, governments pushing back very much, but they are not pushing back on the norm. You will not hear in those debates governments saying, we don't care about this norm. We don't care about children. The premise of the normative structure is accepted, and the pushback comes on the application of the norm. So the debate takes the form and uses language from the normative framework, but still you will get people who have been identified as perpetrators of grave violations using the normative construct, using vocabulary from IHL to argue their point about why they should not be on the list. So a thing to be careful about there. Let's hop down here. This is if you have a counterpart who does not know very much about IHL, but does have an interest in adhering to IHL. So here you have a couple options. You can sensitize them on IHL. It's probably too late to do that if you're in the middle of, if you're engaging with them in the middle of a conflict. Another option is you can frame your norms in terms of a different set of values that might align with IHL. So there's a lot of work that the ICRC does on this in terms of the connections between IHL and Islamic law and other frameworks of values as well. So that is something to consider there. And then we hop over here. Here's the most challenging one. If you have a counterpart who doesn't know much about IHL and doesn't have much interest in adhering to IHL, probably bringing IHL into the discourse or bringing norms into the discourse at all might not get you any traction there. You might still have other tools that you can use, but just looking at the role that the discourse of norms and discourse on IHL will likely play in that type of negotiation, it will probably not get you very far. So that's my framework. This is my little tool that I lay out, and I'll be interested to hear if somehow some aspects of this resonate. I'll be interested to hear in the Q&A if people have other perspectives, maybe there are things that don't fit into this framework, but this is just one way that one can think about approaching some of these areas. I'll just zoom out as I conclude by saying a few comments about how all of this stuff fits into our perception of what is our negotiation capital. This comes from a piece called Building Negotiation Capital from Michael Benalil. He's not talking about humanitarian negotiation in this piece. He's talking about other types of negotiation, but I find it to be a useful framework to lay out. And I've taken it and applied it to humanitarian negotiation in this piece from Negotiation Journal, which is also available on SSRN in case anybody wants to read it. And I also wrote something about that was in the context of COVID, where I applied this framework as well. But essentially, the idea is that if you think about your strengths and weaknesses of a humanitarian negotiator, you can think about it in terms of these different categories of capital. You can think about your cognitive capital, your social capital, your emotional capital, and your cultural capital. So all of these in some way relate to these thoughts about IHL and humanitarian principles and bringing them into a negotiation. Much of what we do when we're, thinking about negotiation is focus on cognitive capital. A lot of the CCHN field manual is about cognitive capital. It's about having some tools to help us analyze our counterpart. So for analyzing the interests of our counterpart and the ways it might align with IHL or not, we're thinking about our cognitive capital. But there's also our social capital. Who are we in relation to our counterpart, especially in thinking about framing, IHL in terms of, Islamic law. I was doing a research interview with a humanitarian negotiator once who said, I'm a white man from Europe. I have a master's in Islamic law. I know it inside and out. But when I am engaging in humanitarian negotiation, it actually doesn't help because my counterparts, he was negotiating in a Middle Eastern country. They don't want some white man from Europe trying to tell them what Islamic law is. So it's another factor is what are your identity characteristics and how does all that play into it? Emotional capital. This relates to what Jonathan was saying earlier about we need to let our counterparts vent. If you're engaging with a counterpart and it's going to be a challenging one, you have assessed that they have a low interest in abiding by IHL. This is going to be a challenging negotiation. This is going to require a lot of emotional regulation on your part. And finally, cultural capital. People think of this in terms of like decorum and sort of cultural norms of decorum. But a large part of it is thinking about your counterpart's values, what types of values and norms are going to resonate with your counterpart, and how do they relate to IHL or not. So I lay that out there as just another way to think about your own progress in the long journey of building negotiation capacity for yourself. So again, I'll end with the elephant because it is a image that sticks in my mind, especially because we are all individuals and we cannot do this alone. If we really want to increase our humanitarian negotiation capacity, we need a humanitarian negotiation ecosystem. This is about organizations offering support to this. This is about finding ways to connect across organizational lines. And that's what CCHN does. So very grateful that CCHN does this work. And I'm grateful to have the opportunity as a researcher to come together with practitioners to talk about some of these issues. I'll just conclude with some of the key takeaways. If you take away anything from this, take away this. Learn IHL. It could be important for your humanitarian negotiations. It can be an incredibly useful tool, but beware of IHL because it can potentially derail your humanitarian negotiations. And finally, learn how and when to use IHL and when not to, and use it strategically. Learn to tell the difference between when IHL can be useful and when it can potentially derail what you're trying to do. Okay, that's what I got. Thank you all very much. Looking forward to the Q&A. Feel free to reach out to me, anyone in the audience who might want to talk more about any of these issues. There's my email address. Thanks very much.
Great. Thank you so much, Rob, for this presentation. And thank you both, Jonathan and Rob, for all these insights. Until now, there are lots of questions which come up from these conversations. And I know that when we were having these discussions in the protection negotiations thematic group, but also in our follow-up discussions, there were many angles and corners we could visit this subject as well. So we have many questions and answers, I'm sure, from the audience. Perhaps going back to some of the questions which were asked in the first round and that we didn't address as well. And I'll ask this question like for both of you as well. So for instance, we had one person who asked a question. They are an ICRC delegate and remember engaging with a non-state armed group that recruited children as young as 10 or 12. So when you raise this issue with them, they reply that in their society, the children are considered adults when they turn 12. They're supposed to get married and leave their parents' house, even if they did not get married. So it was difficult to defend the idea of children being children and not little adults and having to be spared the duty of combat. And here it boils down a little bit to how, like, on one hand, we have these normative, these norms, these international norms that we as humanitarian practitioners have to uphold, or at least feel we are expected to uphold. However, like, there are many considerations in IHL, but also in other legal norms, which do not necessarily align either with the immediate needs and the priorities of counterparts, nor with the customs and the norms as well. How would you manage this kind of discussion, or how would you, if you're, for example, implementing a program to demobilize children or to implement an activity, etc., you want to change behaviors and attitudes, how would you go about that without necessarily using the legalistic terminology as well? What would be your approach on this?
Should I give Rob a chance to catch his breath a little bit?
Go for it.
Okay. I think the issue, particularly on these negotiations around children and age, and be it the one that our ICIC colleague raised in terms of, well, they reach culturally adulthood at a certain time, or on religious norms around the end of childhood, be it menstruation for a woman, facial hair for a man. One thing that I think has worked is that there's often not a monopoly of views within a community or even within a doctrine. So, it was an issue I was working on back in the days I was working with Geneva Call. So I'm going to focus more on the religious side right here, because I have a bit more experience. Although I think in Colombia we did face the issues being raised. I'll maybe try and come back to it. But let me actually overall frame it in this. A lot of particularly armed groups are saying, we're protecting children. Children are coming to us because they have no other means of protection. And, you're telling us that your IHL says that we have to protect children. And then, we're nomadic, we have to go and, everybody's got to pitch in and do their thing. So in that discourse, one thing you can do is say, well, okay, fair enough. Let's try and reach out and bridge the gap and see if there are protection agencies that are available that might be able to take on the children. It's not always the case. Then at least can you get them in backline roles? Because, you're giving them a Kalashnikov and saying, go stay on point over there. Well, maybe there can be less dangerous roles for them. So, again, we're not always going to achieve our highest end goal, but we might be able to achieve some other goals that might ultimately result in greater security. On the religious side, we found that certainly, there are different religious leaders that have different interpretations of these standards. And then, to see, can a dialogue be taken among those groups that have different perspectives, and saying, within this denomination or within this faith, we have different interpretations. Why is your interpretation like that? And to see if there's room along those lines. And then again, even in the really tricky one about, well, this is our cultural standards, again, looking at the internal constituency, probably the internal constituency is going to agree with these armed groups saying, yeah, that's the way we roll. Are there external factors that might have more influence to say, well, we understand that, but maybe you might want to look to the future and say, if you want to have this role in, in achieving your ends, then one of the things I once said is that IHL can be like carrying a backpack towards the course of your ultimate objective. So it might actually imply some weight at times, but when you get to where you need to go, you might be able to find some things in that backpack that, you know, that you're glad you carried with you that will be helpful in the conflict resolution or whatever it is. So that might be something that can also appeal. I mean, again, there's no one size fix. I guess maybe I leave it there because that also sucks up. Hello, is there something particular I missed on that question that I should address?
No, I think that there are just there's these different aspects as well, like, and you mentioned it also in the presentation, and I think that Rob touched upon it when we were talking about like the facts and the norms as well, and finding this convergence as well. I have the impression that also one is really knowing these things, because like the schema that you showed us, Jonathan, this pathway with the different options, etc. Sometimes we think that it's just a one-way street, or that it's just like the law says one thing and that's it. But what it actually also entails is that one really unpacking these different layers of the onion, knowing what the national law says, what the customs and the local customs say about this. And you both mentioned this aspect of being curious and listening to the counterpart, trying to understand where is this like behavior coming from, in order to perhaps find milestones along the way, which may not look like the ideal outcome that we want to achieve, but somewhere along the way, which could be baby steps towards a higher outcome. So I think we did touch upon it as well, but I wanted to revisit it a little bit to remember some of those key messages. We had some hands raised as well. I'd like to maybe take the chance also from before. So we have Christian. I don't know, Christian, if you're still with us, if you would like to take the floor. I know that you had your hand raised from before. So if you'd like to propose your question or ask it, please, the floor is all yours. Okay, Christian, we see that you are unmuted, but I'm not sure if you're speaking.
Hello?
Yes, we can hear you. Please go ahead.
Can you hear me?
We hear you loud and clear. Please go ahead.
Okay. For me, it's not like a question, it's just like a proposal. I'm a Christian Kogabwe from DRC. So what I'll ask if we can have more opportunity to get more options to know about more, how we can start to negotiate. Because we pass through a lot in east of Congo, and we keep and survive. So we don't understand the system, how we can negotiate with conflict, army conflict. So we thank for this opportunity to attend this workshop, and then we keep and ask to provide us more courses to learn about it, so we can understand how we can keep and negotiate with army conflict. Thank you.
Thank you so much, Christian, for this intervention and all the salutation to the eastern of DRC. Indeed, like when we imagined this thematic series and we imagined it in a certain logical pathway, it stems from this analysis of like, why do we feel stuck sometimes with managing or integrating legal normative frameworks into our humanitarian negotiations. So some of that is related to the fact that sometimes even more seasoned humanitarian professionals do not necessarily like know IHL by heart or the other legal frameworks as well. Others relate to how our counterparts perceive these legal and normative frameworks as well. So yeah, the idea of inviting all those speakers like Jonathan and Rob is to provide this opportunity to unpack these different aspects. And just before concluding the webinar today, I will also share with you what are the next webinars which are in line, hopefully to to give you the chance to come back as well. So we also had other questions too, and maybe I'll propose it over here for Jonathan and Rob, and please feel free, whoever wants to jump in, you can. So one of our participants is asking, like, do you no, let me take the other one, is also like to change a little bit. So the current situation is setting a precedent in the way we will negotiate in the future, since like holding actors accountable is being challenged as well. Do you think we need to rethink our techniques and approaches? So that's for any one of you who would like to jump in on this. And there were lots of questions also like around the precedents which are being set, what's happening in the past years undermining the weight of any IHL, international law, human rights-based argument in frontline negotiations. So allow me to conflate these questions as well. What's the credibility of using these arguments now when it appears that some countries, let's say, do not uphold these principles in practice, and how do you address that? Over to you.
I'll say a few words on this, and then I'll be very interested to hear what Jonathan has to say on these topics as well. But maybe I'll take first the question of, is it a challenge to bring the discourse of IHL into a humanitarian negotiation, given the widespread issues with compliance and accountability? And from what again, I come as a researcher who is hearing things from people who are, operating in different contexts. But yes, I hear very much that this is a concern. I hear it at different organizational levels, that we're in an incredibly challenging moment. I have heard many people express a great deal of despondency to me about the state of implementing IHL, and that impacts negotiations in the field, because they just, that doesn't have resonance, at least in some contexts. It is not the case in all contexts, and that's something to be aware of as well. But for sure, this is absolutely a dynamic that I see humanitarian negotiators grappling with. I'll say one more final thing, thinking about, is there a different way forward for grappling with accountability? And I will say here, the way I perceive it is that we're in a very challenging predicament. Thinking about the elastic band that Jonathan mentioned, and thinking about the football players who are self-regulating their football game, to me, those two factors are inherently interconnected. The reason that there is and can be such elasticity is because of the lack of consistent accountability mechanisms. And my sense is that, to some degree, this is by design. States have decided to make IHL be this way. But as Jonathan also mentioned, we do have these moments. We do have these examples of accountability coming in, whether it's the ICJ, whether it's the ICC. These institutions, we can unpack, a lot of their complexities as well. But we might find that, at least in some contexts, these institutions have more power than it might seem if we're just looking at everything from a global level. There's one piece from the field of political science that it's an article called "Can the ICC Deter Atrocity?" And it's a statistical analysis, basically looking at different parties to armed conflict and how they behave. But basically, the answer that the scholars that wrote this article find is that the ICC can deter atrocity. So even amidst this moment where many might be feeling bereft of hope, there are some pockets, some slivers of promise and hope that we can find. And I think that's what we will want to hold on to continue the push forward. That's what I got.
Thank you so much, Rob and Jonathan. I don't know if you want to also weigh in on this question, like with
I mean, I think,
yeah.
Okay. I mean, I don't have anything I disagree with Rob on what he just said. So I think just possibly to build upon it in a way that there is a lot of despondency, and we can, either drown in it, or we can try to come up with some constructive ways to deal with it. I mean, certainly the double standards are not helping, or at least perceived double standards. And I think this is something that's really gaining a lot of ground on social media and in different ways. And, that's, so a lot of it comes back to us as populists to demand consistent approaches to these standards. But I am going to come back to the rubber band, because a rubber band always has a breaking point. And I don't think we've reached it yet, but we could. So I do think, like, I think we have these two things that are maybe counterweighing each other, in the sense that we might have some more judicial activism. And I also want to point out, we had a decision of the Netherlands domestic court that put an injunction on the Netherlands government from sending weapons to Israel based on their finding that there was an overriding risk, or whatever the actual standard was, that these could be used to commit war crimes. So boom, we have a success there. And again, if we count it in terms of what our great expectations are, I think we'll likely be constantly disappointed. But if we look at some of the baby steps that can be achieved, and if we also understand that, again, I say this quite often, we only hear about it when things go boom. And that's a violation. We don't hear about it every day when IHL is in fact complied with, when a commander does make a decision. And I'll just conclude with one thing here. I recently had a conversation with the top military lawyer of let's say a mid-sized Western country. And one of the things he said to me was, we're really looking to get, we were actually talking about the film that I just showed, because part of that shows soldiers, and it shows soldiers debating their roles, and as just rank and file soldiers, like, we've got our soldier cars, why should we really respect these, do we care? And he said, what I really need is to look for ways to build a culture of compliance within my military. So that was encouraging to me, to say the top legal advisor was concerned about saying, how do we create this culture of compliance from within? So, again, everybody has their own role where they can potentially contribute to small steps that make things a little bit better, because that's all we're ever going to get in the political and the global environment that we live in. I don't mean to be cynical, I actually mean to be optimistic that we can make some difference.
Thank you so much, Jonathan, for this, and Rob as well. And also perhaps like going back a little bit by knowing our counterpart, because it's true that when we are, and we will be faced, it's not the first time we are faced like with the slogan of like the double standards, etc., etc. So it's also about sometimes knowing the counterpart and finding the other arguments we can explore as well, which are not necessarily legalistic, but are more into what are the other common shared values we can agree on, whether it's regarding children or women or the civilian population as a whole as well. And I remember also in one of the presentations, we spoke about like incentivization, or what are the other things that the counterpart would like to see out of this successful negotiation that they have with us. I'm aware of the time. I'd like to give maybe the floor. We have Ahmed Al-Shiraji. You have your hand raised, so perhaps we take one or two more questions from the audience, and then I will wrap up with some announcements for the next webinars as well. So Ahmed, if you're still with us, please, the floor is yours. You can ask your question.
Yes, I'm still here. Do you hear me?
Yes, go ahead, please.
Yes. Thank you for your encourage us to be more frank Really, I have a question out of the box. It might need thinking. After 70 years, as you mentioned, do you think IHL and humanitarian principles still functional? Do you think could we put humanitarian principles in the table during humanitarian negotiation, especially in Arab countries, taking in our consider what happened in Gaza and Lebanon? I will give you one example from the field. During negotiation with leaders here, I put principles during negotiation. Do you know what they respond to me? They tell me, forget this song. That's failed in Gaza. Let's talk as traders. Thank you.
Thank you, Ahmed, for this question. I don't know if Jonathan, you want to jump in first.
I have to apologize a little bit. I was getting quite a statico, and I'm not sure I caught the very end. But I think one thing about humanitarian principles that I would like to say is that not all humanitarian actors need to be principled humanitarian actors. So, I think in the Red Cross, Red Crescent movement, we're quite dogmatic about our principles, and we might be to one side of the spectrum in terms of, particularly ability to cross over front lines and to be able to engage with all parties to conflict. I also think there's been very effective faith-based humanitarian interventions, or maybe even, let's say, politically or driven humanitarian interventions that can also be very effective. So what we want to have is a spectrum of possible interventions that all work somehow together, that if you only had one of them, it would be tough to cover that entire spectrum. But the ability to have different actors out there having different approaches will result in, I think, the best outcome. So we don't need to necessarily abandon principles, but we can certainly be very open towards the type of humanitarian actors who can intervene.
Thank you, Jonathan. And if I may add also, I think one of the questions we can ask is what would happen if these principle and legal frameworks did not exist? What would the situation look like as well? I don't know if, Rob, you want to jump in on this question, or if we take one last question from the audience before we conclude.
I was just going to offer a comment just to frame this moment in time, that this is a long game that we're playing here that spans the entire course of human history, the effort to try to mitigate suffering during wartime. And if we look at the history, looking back, World War II, World War I, the Napoleonic Wars, we see these outbreaks of great, immense violence and suffering. But after each of those conflicts, there is a moment of trying to reconstitute some type of framework of norms and laws that can work potentially better next time. That's the hope, that's the aspiration, and that is the long arc that humanitarian negotiators are trying to push forward. So I just wanted to frame our current moment in that way as well. We might not be at the point in the arc where we want to be, but that does not mean that there is not value in continue to trying to